Wow. Whoa.
Excuse.
Came right at you. No, that's a legitimate question. Thank you, counsel.
Excuse me, I don't go back to work until January the 5th.
Oh, so you had time to stay in. Why'd you tell me you didn't want to lose
That's
your
all
job?
for Christmas, Your Honor. That ain't now.
Before we even get into what you're about to hear, understand this. This is a bond compliance hearing that quietly turns into a high-stakes moment. The defendant is already on thin ice. Community corrections deadlines have been missed, and the judge is clearly testing credibility from the very first exchange. What starts as a routine clarification about work dates quickly exposes contradictions, confusion, and risk of jail time. Stay with this case closely because every answer here matters, and one wrong move could mean immediate custody.
That's all for Christmas. The last day is the 23rd. Let's start it here, okay? Can I talk?
Not yet, ma'am.
Oh, okay.
Is there going to be an attorney saying something?
Assistant Public Defender, Mr. Davi Lee, Your Honor, on behalf of Ms. Tracy Reed. Mr. Miller has been appointed, however, I did speak to her about the bond violation.
Wants to argue.
Your Honor, Ms. Reed indicates to me that she did go do community corrections on the 11th. However, on the 12th, she was unable to remain as she had to go to work. However, she does come to understand that now it's important that she goes to community corrections, stays there until she is called, and there will not be any further violations.
But they did have the wrong number. They have the number from 2014. That's not my phone number no more. She never asked me
They
for my
set
phone.
an intake appointment for December 2nd. Did you go?
No, sir.
Why?
When I went on the first, I explained to the lady that I just received the job. I gave him the intake paper that I gave the judge when I got arraigned. I told the lady, I said, listen.
Ma'am, go ahead.
Well,
Go ahead.
I asked her, could I come at a different time? She told me that that was the time that I needed to call and see if I could get an attorney. Every time I called, I didn't ever get to her. So no, I didn't go back.
What do you mean every time? Every time you call,
I called her twice.
how come you didn't go back up there?
Cause I don't know, just I ain't gonna lie.
So I have no test results.
No, I took the test results. It's right here. I took the urine.
Well, the one, yeah. But since then, I don't have anything.
He only told me to drop once a month. He told me to go once a month and drop.
That's correct, but how were you gonna go back if you didn't do the intake?
I didn't know I had
How
to
are
do
you
the
gonna-
intake in order to keep dropping.
What?
I didn't know that I had to do the intake in order to keep dropping because I didn't do the intake when I dropped you
How are you gonna know when to?
on the first.
You have to do the intake. So that then they will then tell you when to test.
Okay.
You understand that?
Yeah, but I was assuming that since I had to go on the first to drop, I only got to drop once
See,
a month.
here's
I'm
the
thinking
problem.
every month on the
And
first.
that is, if you had gone on the second, they would have been able to explain all of that to you, but you didn't go.
Yes.
So, Ms. Reed, tell me why I shouldn't just like you.
This is the moment where the courtroom shifts. Legally speaking, failure to complete intake for community corrections is not a minor issue. It breaks the foundation of bond conditions. Intake isn't optional paperwork. It's how testing schedules, compliance tracking, and supervision begin. The judge is no longer asking questions. He's weighing incarceration. Notice how confusion is no longer an excuse here. From a legal standpoint, "I didn't know" doesn't override a signed bond agreement. At this point, the defendant is relying entirely on judicial discretion, not entitlement.
You up because you didn't comply with your bond.
Jesus, please.
Tell me why.
Because I'm going to the next one. I went over there this morning. I came in at 9. I thought my court date was at 9. I came, they told me it was at 1. I went up to community corrections and they told me that they couldn't do that. I had to get another
Stop talking. Just
referral.
Stop. Because you're gonna say something and it's just gonna get bad.
Oh, Jesus.
No, it's judge, but that's okay. You're enjoying that gum, aren't you? That gum is taking a beating.
You're making my nerves bad. Got the police standing behind me like he about to handcuff me. I'm sweating. I can't go to jail. I
No,
can't.
you can.
I'm too old for that. That's I can't. Please. No. Please no, sir. Your Honor, Judge Simpson, please. I just got my good job. I no.
Okay, at least the one benefit is you're on, and the only thing that I'm not gonna lock you up today. The only reason I'm not doing is run monthly. You're still within that month, and the test that you took was negative,
Absolutely.
but then you didn't do this. You take the next test.
Okay. I'm going over there right now.
So I'm gonna prepare new orders. I'm gonna adjourn our probable cause to January 2026, 9 a.m. We'll do a new community corrections referral for testing. You stay over there today when you go over until you complete that intake.
Okay.
You hear me?
Yes,
Because if
sir.
you come back here and you haven't done the intake, there's nothing you're gonna be able to say to me.
Okay. Now I have another question.
Oh.
Before all of this happened, I had plans to go out of state for New Year's. So I need the permission to go because this has been planned and paid for.
Where are you going?
To New York to watch the ball drop.
You are not. No, you're not. You are not. Who is that? I don't know who she is. I don't believe her. You're gonna go watch the ball drop.
Yeah.
Where?
From what's the name of it?
Like Times Square?
Yes, down by Times Square. We stand in a room.
There's a whole lot of rooms by Times Square.
Yeah, I don't know right now.
This exchange may sound casual, even humorous, but it's actually critical. When someone on bond asks to leave the state, especially for leisure, judges immediately assess flight risk and seriousness. The hesitation, uncertainty about travel dates, and lack of concrete planning all undermine credibility. Judges read behavior as much as words. The concern here isn't New York, it's whether the defendant fully grasps the consequences of noncompliance. Courtrooms may joke, but decisions are rooted in risk assessment.
Nerves bad, I'm telling you.
You're gonna go watch the ball drop.
Yes.
Are you gonna be outside watching the ball drop?
Not if it's real cold. I'm hoping we can see it from the
It's
hotel.
gonna be cold.
But it might not be that.
Have you ever been there?
No, that's why I want to go.
She has never been around that many people.
in my life,
Yeah, I know. And you have no idea what that's like.
but I want to go.
I know. And I have a feeling if I let her go, she ain't coming back.
I
She'll be
am.
lost someplace in New York.
No, I'm coming back.
When are you supposed to be leaving?
What day we leave?
So you don't even know. How do you not know? How do you not know when you're
Because
leaving?
I work and she take care of all the business. Now we leaving on the 30th.
When are you coming back? Well, never mind. When are you coming back? On the 7th?
Second.
2nd. Hold on a minute. So you're going to New York basically for just a few days.
Yeah, just to see the ball drop.
I'll tell you how you can see the ball drop.
I don't want to watch it on TV.
Because that's what I was gonna say.
I want to
You
go
can
in
see the
person.
ball drop.
It's already paid for. We can't get the money back. I don't want the money back anyway. I want to go. But I have to have permission. Because if I get stopped and then they be like, oh, you're stopped, and they try to take me into custody. No. Just me making my nerves
If I
bad.
just lock you up, you wouldn't see the ball drop.
Okay, so here we go. You just said you weren't gonna lock me up. Now you want to go back to that incident. I'm not gonna do that. Just
Counsel, whichever one's representing you, prepare an order to the effect unless there's an objection from the people to let her go watch the ball drop.
She's got permission to take the time off of work.
I
Wow. Wow. Whoa.
excuse,
Came right at you. No, that's a legitimate question. Thank you, counsel.
excuse me. I don't go back to work until January the 5th.
Oh, so you had time to stay in. Why'd you tell me you didn't want to lose
That's
the
all for
job?
Christmas, Your Honor. That ain't now. That's all for Christmas. The last day is the 23rd. Today's the 11th. My glasses back on. Why you keep walking by me? Stay away
You know
from
what?
me.
Take those glasses off. You don't need them.
They my safety guys. My told you my nerves back. The police keep trying to come over here.
I got it.
So I can go?
Are you driving?
Yes, we're gonna drive.
She gave an adequate answer to the work question. You're gonna drive
Yes.
through Canada, or you just going straight through the States?
I'm going through the States. I'm off to the 5th. We go, you know.
Yeah, because if you go over that border, you ain't getting back. All right.
Okay. So who gonna give me the paper saying I can go or I can just
I will prepare the
You know
order.
what? She needs to stop asking me questions.
I'm gonna prepare an order till.
I've already prepared the order because you were taking so long.
Thank you, Your Honor.
Bye.
In the end, this case comes down to conditional mercy. The judge chose restraint over incarceration, but made expectations unmistakably clear. Complete intake, comply fully, and do not test the court's patience again. This ruling highlights a core principle of the justice system. Discretion is earned through accountability, not excuses. Bond is freedom with conditions, not freedom without limits. If you found this case as intense and revealing as we did, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom breakdowns where every word counts.